Memorandum on the Deferred Enforced Departure for Certain Palestinians. President Biden directed the deferral of removal of certain Palestinians who are present in the United States. The United States will defer for 18 months the removal of any Palestinian subject to the conditions and exceptions provided in the memo. Those not included are those who have voluntarily returned to the Palestinian territories after the date of this memorandum, who have not continuously resided in the United States since the date of this memorandum, who are inadmissible under Section 212A3 of the Immigration and Nationality Act, 8 U.S.C. 11A2A3, or deportable under Section 237A4 of the INA, 8 U.S.C. 1227A4. Who have been convicted of any felony or 2 or more misdemeanors committed in the United States, or who meet any of the criteria set forth in Section 228B2A of the INA, 8 U.S.C. 1158B2A. War subject to extradition, whose presence in the United States the Secretary of Homeland Security has determined is not in the interest of the United States or presents a danger to public safety, or whose presence in the United States the Secretary of State has reasonable grounds to believe would have potentially serious adverse foreign policy consequences for the United States. He also authorized employment for non-citizens whose removal has been deferred as provided by this memorandum for the duration of such deferral. Federal judge questions. Controversial Texas immigration law amid court battle. A federal judge on Thursday expressed concern and skepticism over a controversial law that makes entering Texas illegally a state crime while hearing oral arguments over a motion for a preliminary injunction to block the law. The Measure SB4, which is set to go into effect on March 5, grants local and state law enforcement the power to arrest migrants and state judges the ability to issue orders to remove them to Mexico. The Department of Justice has sued the state, arguing the federal government has exclusive authority to enforce immigration law, U.S. District Judge David Ezra emphasized that he was sympathetic to the state's concerns about the complicated situation at the border and the issues plaguing the country's immigration system, making it clear that something must be done to improve the nation's immigration laws. Ezra sharply questioned several provisions within the law and flat out rejected the state's argument that an invasion was taking place at the Texas-Mexico border. Ezra said he would rule as quickly as I possibly can, assuring both parties he would give enough time for either side to file an appeal. USCIS increases filing fees, effective April 1, 2024, effective February 26, 2024. Premium processing fees will increase from $2,500 to $28,805. These changes apply to premium processing requests received on or after February 26. Premium processing will now be counted in business days rather than calendar days. This will mean that the standard non-immigrant premium processing time of 15 days will increase from approximately 2 weeks to approximately 3 weeks. For those matters that have a 45-day premium processing time, e.g. national interest waivers, EB1C multinational managers, the processing time will increase from approximately 6 weeks to 9 weeks.
Friends, show us some love and smash the like button. It doesn't cost you anything. If you have an immigration problem or need a second opinion because you cannot get a hold of your own lawyer, schedule a meeting with our team. Share information with our CARES team and they will help you get scheduled with our legal team.